Toll versus Eric Sims.
For the record, this matter is before the court on the defendant father's objection to a referee recommend order that denied his request for parenting time on account of his failure to appear, that he appeared late. This hearing is being conducted via Zoom. Present is Eric Sims, defendant father, as well as plaintiff mother Kendall and Lewis Toll. Good morning, everyone.
Good morning.
Ms. Toll, Attorney Zagorski did contact the court this morning advising that she was ill this morning and had hoped to appear on your behalf. I understand you don't want to do anything until she's here, but the reality is we need to move this matter forward. The court's going to be off for a period of time in January. I don't want to sit on this for a month. Excuse me.
Judge, may I interject?
The court is proposing that dad have supervised parenting time at Family Counseling Shelter Services, which is supervised by a master's level therapist. It's safe for the child, and at least it starts that process. There's a waiting list, so it's not going to happen overnight. So that's what the court was.
The hearing begins with a problem that immediately tests how the court balances fairness against delay. One attorney's absence could have justified another postponement, but the judge clearly signals that this case has already waited long enough.
The court was contemplating. Ms. Toll, you're opposed to that?
I am, because there's other things that we would like to discuss with you before anything moves forward. It's very important that we bring that to your attention.
Okay, go ahead.
I don't want to do that without my lawyer, Your Honor.
Well, she's ill and we can't sit on this. And let me ask Mr. Sims. Mr. Sims, did you complete the probationary terms? And this all started when you assaulted your girlfriend, Alyssa Kendi, in front of your child. Was there a criminal conviction for that?
There wasn't. Excuse me, it wasn't in front of my child.
Okay, well, that's what was alleged. Are you on probation for a assault conviction?
No, I'm not on probation for that matter.
What happened to the charge?
I was found guilty, did 7 months in jail.
Okay. Do you still have a relationship with Alyssa Kennedy?
Absolutely not.
Okay. Did you ever complete an anger management counseling program? That'd be important.
No, I wasn't ordered to do so.
Well, the court thinks that if you want to establish a relationship with your son, then maybe you should enroll in an anger management counseling program that can assist you in controlling your emotions and anger.
So I'm in a separate program for that.
What do you mean you're a separate program for that? You said you're not on probation.
No, I'm not in.
Completed such a program. I'm suggesting you should.
I'm not in an anger management program. I'm in an MRT program.
Okay. What is MRT?
Moral Reconation Therapy.
Are you on probation to some court? Are you ordered to do that?
Yeah, I'm on felony probation.
Oh, all right. That's what I'm trying to get at. So you, for the software, let's kind of, you were just given straight jail time. What are you on probation for? What type of criminal conviction?
Assault with a dangerous weapon and R&O.
And as part of that, is that here in Monroe County?
Sure is.
Okay, assault with a dangerous weapon, and you're on probation. When did your probationary term expire?
In August
of 2024.
Yep.
And you are right now taking a class called MRT.
Yep.
And what does that stand for again?
Moral Reconation Therapy.
Does that class touch upon anger management issues?
I mean, it touched down on everything okay. Morally.
So how often does that class, do you attend those sessions? Once a week?
So I attend twice a month. I will be completed with that class, I would say, before the end of January.
Okay. Well, I think it's important that what you want to do is you want to provide Ms. Toll as well as a court written verification you completed that program successfully. think that's important. Obviously, your child has a right to have a relationship with you, and the court wants to move forward with that. Ms. Toll wants to talk with her attorney. Obviously, but that would help considerably if you can provide documentation that you've completed that program, what it entails, a brief description, you've successfully completed that program. That is very important. Ms. Toll, are you opposed to Dad even having phone contact with your 11-year-old? FaceTime?
Documentation suddenly becomes one of the strongest forms of evidence discussed during the hearing. The judge repeatedly emphasizes written verification because objective records often carry far greater weight than verbal assurances. That instruction creates a roadmap for the father's next legal step.
Right now, yes,
Okay. And why is that?
because he would be confused, and he's doing really well right now. And the last thing I want is for it to affect his school and everything that he is doing right now.
At some point in time, he's going to have a relationship with his dad. You understand that? You accept that? I mean, and it's not like, well, we're going to wait till he turns 18 to have a relationship with his dad. That's not going to happen.
I do hear you, but there are many factors in this situation.
Okay. Is your son currently
Mr.
in
Sims,
counseling?
what was that?
Is your son engaged in counseling?
He was. He has been
Okay.
multiple times over the years, and there's a lot
Okay.
of stuff he has seen and heard that really affected him.
Okay. I know there's an incident that occurred in September of 2022. That's what would prompt his court to spend Dad's parenting time with your 11-year-old son. So the counselor does not believe he needs any more counseling then, correct?
He is not right now. No.
Okay. The whole purpose of counseling is to work through the issues he's got with his dad and what he has seen.
Right, but
So if in fact, if you believe your son's not ready to reestablish a relationship with his dad, then you need to get him back into counseling.
I can get him back into counseling.
Okay. That's critical. So you're opposed to Dad having any contact with your son right now, with his son, I should say.
Our son, yes, I am. I'm sorry.
Right. All right, so I'm going to put it over a couple of weeks, but again, I'm let you know we're going to move in that direction. Ms. Toll, we're not going to. There's no reason why we cannot move forward with family counseling shelter services, but we will adjourn this to a couple of weeks. Mr. Lewis, Mr. Sims, going to give her a chance to have her attorney present. How about the week of the 17th, 23rd, 24th?
17th is, I could do 3:15. 17th.
Okay.
Next week's a bit more.
Okay. What did you say?
I have on the 24th, I have 1:30.
Ms. Anderson, we'll adjourn this matter to the Wednesday, January 24th at 1:30.
Yes, Your Honor.
So, Ms. Toll, you need to notify Mrs. Gorski. She's got to make it work. It's a Wednesday, January 24th at 1:30. So if we could put in your recommendation, Ms. Andrus, that Ms. Toll wishes to have her attorney present, so the matter is adjourned to January 24th, 1:30 via Zoom. Will that work with your schedule, Mr. Sims?
Yep.
All right. So make a note, it'll be a Zoom hearing, Ms. Toll. It's your obligation to reach out to Ms. Sikorsky. She did not file this objection, you did, so the copy mailed to you and to Mr. Sims. You need to forward that to her. Let her office know as soon as possible, January 24th at 1:30. And we will address it at that time. And Mr. Sims, the court again would suggest that make a note as soon as you complete that program, that MRT program, you want to provide written documentation, basically what the brief description of what that involved and entailed, as well as your successful completion of that program and how long it was. So I'm sure you get a standard letter to that effect. That will help. I don't know if you'll have that by January 24th, but as soon as you're done with that program, you want to get that
I'll
letter.
make sure I do.
Okay, if you can get it before the 24th, that would be great. You can then fully move forward. And Ms. Toll, if you still are opposed to your son having, because it's your son and Mr. Sims' son having contact with his dad, you need to get back into counseling because that's what the court's he has a right to that relationship with his dad. So if you believe he's got some issues, you need to get him to counseling to work through those issues. All right, so that will You both mailed a copy of the recommendation. We'll adjourn this matter January 24th, 1:30.
The scheduling discussion may seem procedural, but it quietly establishes accountability for every participant before the next hearing arrives. Each parent leaves with specific responsibilities instead of vague expectations. The mother's obligation centers on ensuring legal representation is prepared, while the father receives clear instructions regarding proof of rehabilitation. The closing remarks reveal the court's broader objective beyond this single hearing. Every instruction points toward one central question: whether a safe parent-child relationship can realistically be rebuilt through verified effort rather than courtroom promises. The judge places responsibility on both parents simultaneously. The father must continue producing evidence of personal growth, while the mother must actively support therapeutic resources if she believes the child remains emotionally unprepared. That shared responsibility prevents either side from shifting the entire burden onto the other. Instead of declaring winners or losers, the hearing ends by establishing measurable standards that will shape every future decision. In family court, sustained action almost always carries greater influence than emotional arguments delivered inside the courtroom.